So in one day, you're saying he made how many calls?
28 calls to the complainant's phone.
Well, Judge,
Phone calls.
this would violate my client's 5th, 6th, 8th, and 14th off the top of my head constitutional rights.
Don't contact the complaining witness. Don't use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness. Hey,
We're here on Mr. Wiggins. I'll let him.
something else happened?
So, Judge,
No.
he has been consistently calling the complainant from the VPO from jail. I believe at last check on Friday, it was since March 26th, it was 130 times or something like that. Yeah. So,
Back in.
Well, he's in
He's
custody.
already-
He's in custody.
No, ag seg. Goes in ag seg. Okay, so guys, for the record, please announce yourselves. State.
Anna Eady, EADY, for Mr. Wiggins.
Nathaniel Meunier spelled M-U-N-I-E-R, also for the defense.
State. You wanted to bring something to the court's attention.
Yes, Judge. So we had received a call that Mr. Wiggins was in violation of the protective order that was in this VPO, and that he was reaching out to the complainant witness in this case. We have checked the jail calls. Those jail calls show that since March 24th, which is, of course, after the October VPO. Since just March 24th, we have 293 calls made to the complainant's phone number. Just yesterday, we had, I believe, 28 calls to that number as well.
So in one day, you're saying he made how many calls?
So yesterday, he attempted 28 calls to the complainant's phone.
My understanding is that there's no longer a protective order in effect because it's been long enough that the protective order.
There's an order for him not to have any contact with her.
Are those part of his bond conditions?
Yes.
My client's not on bond.
He is not supposed to have any contact with her whatsoever.
I understand, Judge, but the way that this court and other courts in the county have structured those conditions have been bond conditions, which my client is not on a bond. He is in custody. He has not broken
I
the
have
law.
ordered him, even though he's in custody, not to call her.
I understand, Judge. Assuming that he had violated some form of a court order that is not a bond condition, I believe the appropriate remedy would be contempt, and which would be a separate criminal proceeding. At the same time, for Ms. Eady talking to me today, it sounds like that the court was going to order ag seg in the jail, so the formal
The only
term-
way that we can revoke phone privileges on someone is ag seg.
Yes, Judge. My issue with that is it's a hammer when a scalpel is needed. So while I understand that the district attorney's office has alleged that my client is called a victim in this case, there's no protective order in place. The bond conditions are not in effect because he's not on bond. Thus, no crime has taken place. And third to that, Judge, if he's to move to ag seg, he would not be able to make any phone calls, not just to the victim, but anyone, including counsel, which while we are here on a misdemeanor, he is in custody on a felony and relatively serious felonies. And
The
not being
only
able.
way, but okay, I understand your plight,
Yes, Judge.
but there are other remedies for you to be able to communicate. Letters, in person, but the only way for me to be able to ensure that the complaining witness is not called is to put him in segregation. That's the only way.
Judge, the problem is nobody would be able to call, including our office as well as his felony attorneys. Letters through the
Write a letter.
jail are notoriously slow. A letter to my mother who lives in the same city takes 4 days. Add in the jail, you're taking over
And
a
I'm
week.
willing to put him on the docket one time a week so you guys can have contact.
Which the
But-
problem is, Judge, we would no longer be able to have any form of private contact, and that would only take care of the misdemeanor and not the felony. And not to be impolite, Judge, him having conversations with us are saying, hey, what's going on with the felony? And any jail visits that take place in ag seg are actually recorded. They're notified by counsel going through the door that those calls are being recorded.
I don't have any other option to not
Well,
prevent
Judge,
phone calls.
this would violate my client's 5th, 6th, 8th, and 14th off the top of my head constitutional rights. Right, self-incrimination, because every conversation is going to be monitored going in and out of the jail because they're going to be recorded via jail visits. He will no longer be able to have private visitation inside the courthouse.
You can pull them out. You can have private visitation in the rooms
It's
there.
not about me, Judge. It's about felony court. It's a serious issue, but that's the.
Why are
fifth
you
thing.
worried about felony court?
Because that's why he's in, Judge. Then
Well, it's also in because of ours. Our bonds are at $60,000.
I understand, Judge, but the reason that this is taking as long as it is and it's been taken as serious as it is because he's in custody on a felony. And this court making him to where he cannot participate fully with counsel is...
There are other means for you guys to participate, but I've ordered
So-
you not to have contact with her. You've called her now over 300 times. I don't understand why you guys aren't filing additional charges anyways.
Sorry,
But
Judge, I missed the last statement. I'm
The
sorry.
only way that I can prevent him from making 300 phone calls is to put him in another wing.
I was going to talk with the DA, and obviously, if my client's making these calls, and that's an if, he's dialing a single number, the jail's numbers can be easily blocked. I've done it on my cell phone numerous times when I've changed cell phones. Over the weekend, last weekend, I had 15 jail calls from one client. And as annoying as that is, it's very easy to block it. And I assume the victim could do the same. I have not heard anything from the state.
Tell the victim what to do, Nathan. I'm not gonna say, can you please block your number so we can't call you?
The least restrictive means, Judge. Strict scrutiny dealing with constitutional rights.
No other way to prevent him from making phone calls. I have acquiesced to you guys before and I have admonished him before. Please don't. We put you in seg last time. You were there a month. You came here begging and pleading, I'm not going to do it, I'm not going to do it. And now we have 300 phone calls. So I don't know what else to do. But now back into Act Seg.
I'm going to sprinkle the word allegedly to the phone calls because it's the kind of thing where records would exist that have not been provided to the defense by the state.
Do you have the records?
Well, I mean, I have them, I just have to get I have to do the forms or get them up with the forms, yeah.
Okay, so let's set up a formal hearing because I don't want. You're right. I don't want to give you state the benefit of the doubt without him actually or Anna actually seeing it and seeing that the phone calls were actually made. So let's set up for a formal hearing. How soon can you get him the evidence?
And if we could keep him in normal population so that we could visit him, as does his felony counsel, and they
Mr.
can
Wiggins, I'm
in our
going to have you sign an affidavit from today promising me you're not going to reach out to the complaining witness in this case by any means. If you do, I can have a contempt hearing, and every single time it's punishable by up to 6 months in jail and a $500 fine per the advice of your lawyer. Because he thinks this is the correct avenue instead of Ag Seg. Do you understand?
No.
Don't contact the complaining witness. Don't use anyone else to contact the complaining witness. Don't use anyone else's number to contact the complaining witness.
I'm going to rephrase what he just said. That means calls going through third parties. So if you call mom and have mom call her, that's against the rules. If you call mom and have mom forward the call, that's against the rules. Etc.
Yeah.
Okay.
This is the affidavit that you're going to sign promising me you're not going to contact her or the complaining witness in any of my misdemeanor cases. Do you understand? We'll have a hearing on Monday to see whether he's actually making the phone calls that we ordered him not to.
This is you swearing that you will not make these calls.
And let it be clear that it truly have no least restrictive means deny his ability to make phone calls to the complaining witness. There really is no less restrictive means.
Judge, my understanding is that the jail can prevent Mr. Wiggins' SPIN number from calling him.
He in the last time he used someone else's SPIN number to make the phone calls.
And what's last?
So,
Yeah.
well, we'll see this time. I don't know. Okay. All right.
Just before we start the record, Mr. Wiggins, I want you to make this aware that this is the court having you swear, which is legally binding, that you will not be making any calls. And if you violate this sworn oath, then that is punishable under the law. Do you understand?
Sure.
Okay. Thank you, Judge.
Thank you.
Thanks, yes. So much.
And that's where this courtroom hearing gets really interesting. Because on the surface, this sounds simple. The judge says, "Do not contact the complaining witness," and the court is told there were hundreds of calls. From a layman's perspective, you might think, well, if the order says don't call, then just don't call. But the defense is looking at something much bigger. The attorney isn't necessarily arguing that those calls should have happened. He's arguing about what the court is legally allowed to do in response. His concern is that putting the defendant in segregation could have consequences far beyond stopping those calls, including making it harder for him to communicate privately with his attorneys about a separate felony case. And then you have the judge on the other side of that equation. The judge's position is basically, I have already warned you. I have already used segregation before. You were told not to make these calls, and now we're talking about hundreds of them. So what exactly am I supposed to do to make the order effective? That is the heart of this hearing. It's not simply about a phone call. It's about the collision between court authority, public protection, constitutional rights, and the defendant's access to counsel. And I think the most important moment comes at the end. Instead of immediately treating the allegations as proven, the judge orders a formal hearing so the actual call records can be presented and reviewed. That matters, because allegations are one thing, evidence is another. The defendant is then given a very clear warning. No direct contact, no third-party contact, and no using someone else's number to get around the restriction. So, from a legal perspective, this judge is trying to draw a very precise line. Protect the complaining witness, enforce the court's order, but still give the defense its opportunity to challenge the evidence. And from a layman's perspective, the message is brutally simple. If the court tells you to stop calling someone, stop calling them. Because once that warning is on the record, the next phone call could turn a courtroom argument into a much bigger legal problem. And that's what makes this hearing worth watching.